This Social Security measure gives at least some protection to 30 millions of our citizens who will reap direct benefits through unemployment compensation, through old age pensions, and through increased services for the protection of children and the prevention of ill health.
Hello everybody, welcome back. Another day, another case. So go ahead and hit that like button for me just to go ahead and give it a tickle. And we're going to be talking about something called Helvering v. Davis today, which is a case that found certain sections of the Social Security Act constitutional. And before we go ahead and get into the case law itself, that little bit of history to help set the context. Stock market crashes in late 1929, right? After that, the economy isn't doing so well. We then get FDR into the presidency, and his administration, along with Congress, pass a series of bills, a series of laws that become known as the New Deal. Now, these were largely social welfare programs and work programs geared to do things like decrease unemployment, help kickstart the economy, and hopefully prevent issues like starvation and the spread of disease. Now, in terms of the United States system itself, our sort of social life, by the 1930s, we were basically the only industrialized country that did not have a government-led social welfare program. Some kind of retirement plan, a pension plan, what we call now the social safety net. Though it should be noted that at the state level, there were some states that had similar programs in place, but obviously being an individual state as opposed to a federal government, the programs were smaller, they weren't quite as well funded, but they also served a far smaller population. Having gotten several committees together and going through significant discussion, we ended up passing something called the Social Security Act, and it was signed in August of 1935. Now, this particular act and the amendments that come after it formed several programs within the Social Security system. This included things like unemployment insurance, retirement, which we still have, disability payments, which we still have, and other similar need-based or insurance-based programs. The law now in place, they have to fund it. And to do so, the government instituted something called a payroll tax. Now, that literally means it comes out of your pay as you work. Now, today, we know this particular tax as a FICA tax. And if you're in the United States and you look at your pay stub, you're going to see those taxes removed from your paycheck. The entire tax is basically split between two entities. Your boss pays half and you pay half. And in terms of your retirement benefits, which you do still get if you work in the United States, with some exceptions, it's a regressive tax, and how much you put in is tied to how much you get out later on. Now, back in the 30s, some people didn't like this so much, and one of them is actually the reason for the case we have today. The shareholders of the Edison Electric Illuminating Company of Boston sued to stop the corporation itself from withholding these payroll taxes. The corporation itself turned around, looked at the shareholders, and said, "Screw off. The law says we have to do this, so we're going to." Those shareholders then requested something called an injunction, which is to stop an action. So they're asking the court to force the corporation to stop withholding the taxes. And the court found that the tax on the employees wasn't properly at issue and the tax on the employers were constitutional. As a result, the injunction was refused, the case was dismissed, and then the shareholders appealed, and it went to the First Circuit. And the First Circuit had some fun, found that Title II, which relates to the benefits, was void as an invasion of the 10th Amendment, which we'll talk about later. And because Title II falls and is void, it basically drags Title VIII, which related to the taxes, along with it. And then just for good measure, they also tossed in that Title VIII, the excise, the tax, wasn't a term being used as it was known when they wrote it down in the Constitution. By the time this case gets to the Supreme Court, Judge Cardozo is on the bench and he's the one writing this decision. And he found that before the court were two specific questions. One, whether the tax imposed upon employers by Section 804 of the Social Security Act is within the power of Congress under the Constitution, or basically, does it violate the 10th Amendment, and whether the validity of the tax imposed upon employees by Section 801 of the Social Security Act is properly an issue in this case, and if it is, whether that tax is within the power of the Congress under the Constitution. So just remember, for purposes of this case, question number 2 is predicated on the answer to question number 1. Before the court even got into any discussion of the constitutionality of the Social Security Act, he first turned his eyes toward the injunction, the remedy that the circuit court gave. And in that instance, Judge Cardozo said providing an injunction was inappropriate because in this case, the cause of action itself, the lawsuit, wasn't pleaded or requested in equity. It was done so in law. And as a result, it was improper to give a remedy in equity. So having said what he wanted to say about the equity and the injunction portion, we now turn toward the actual merits of the case before us and those two questions originally presented. Now, it's all going to turn on the power of the Congress to act, because in our system in the United States, we have two sovereigns, the federal sovereign and the state sovereign. And our system says that unless a power is explicitly given to the federal government, they don't have the power to act. That power then is remanded to the states or the people, and that's explicitly stated in our 10th Amendment, which is where this action is basically being fought. And because of this, we now end up in a mini history lesson. So when the Constitution was originally being drafted, they included a power to Congress where they say that Congress can spend money in aid of the general welfare. And that's in Article 1, Section 8. Now, at the time, there's a big debate about what general welfare means, and the court said that the view Hamilton is espousing in those debates wins out over Madison. Basically, Hamilton was arguing for expansive federal powers. Madison was arguing for a restricted federal government. The court here is saying Hamilton wins, and as a result, they then go into a discussion of what general means. Well, they sort of do. Judge Cardozo basically says that even where you sit and say that yes, the general welfare is broadly read, which is what he's saying, you still have to take into consideration application. So what is general welfare as opposed to a particular welfare, where that line is. And he does say that you can't know where that line is in advance. There is a large area of discretion, but that discretion doesn't belong to the court. It actually belongs to Congress. And that is always going to be so unless the choice is clearly wrong, which I think is an interesting phrase, a display of arbitrary power, and as a result, not the exercise of judgment. And then this particular line coming up, I found very, very interesting. He said that we have to also note that the very concept of general welfare isn't static, but changes to meet the times. Needs that were narrow or parochial a century ago may be interwoven in our day with the well-being of the nation. What is critical or urgent changes with the times. Now, if you've at all paid attention to the Supreme Court nomination process over the last couple of years, or you're in law school and you've had these debates, you're going to recognize that as a major thoroughfare in the argument between originalism and the living constitutional doctrines. This is a very, very clear statement of a living constitution doctrine. The idea being that the Constitution is alive and breathes and grows with the population. So the meanings of the words can change over time as the meaning changes within the common use of the population, as opposed to originalism, which basically says the word means what it meant when they wrote it down. And as a result, it should be interpreted in that fashion. Reach out in the comments down below. Are you more of an originalist, or are you more of a breathing constitutionalist kind of person? It's always a fun conversation. Judge Cardozo goes through then a discussion of what was happening about that time. So he looks at the Great Depression set off by that stock market crash in 1929 and the collateral effects of that action, namely the effects of unemployment, the loss of housing, etc. And the court said that unemployment was not a particular ill, but a general one, which can be checked by Congress if they choose. But they also then did something interesting, and they took it one step further. And the court said that the line for unemployment is basically the same or similar whether you lost your job because the job disappeared or because you're not able to work anymore. Rescue of that individual, the court said, was necessary irrespective of the cause, and the Social Security Act is there to save people from the poorhouse and the haunting fear that such a lot awaits them when the journey's end is near. There was then a discussion about the Social Security Act itself and how it was formulated and came to be. And the court pointed out that there were a series of factors that the president's administration and the associated policymakers had considered. These things were like the number of persons in the United States 65 age or over were increasing proportionally as well as absolutely. There was also an increase in the number of persons unable to take care of themselves, and the population was becoming more urban and industrial rather than rural and agricultural. And this ends up changing the nature of unemployment and poverty within the United States, at least when it comes to populations in large urban centers. So looking at the totality of this, the court found that the problem was, as they put it, plainly national, and that individual states couldn't deal with it effectively. The states themselves often lacked resources needed to handle unemployment at this kind of level, and they were also, the judge noted, less inclined to raise taxes and increase other burdens for fear of making themselves less attractive in relation to other states for citizens to live in. In effect, they didn't want to lose the tax base of the person at all when they fled to a different jurisdiction. In looking at the wisdom of Title II, the benefits program, the court passed on that question and noted that it's power, not wisdom, that the court deals in, as they found that the general welfare is something that could involve the payment of unemployment benefits. The court found that where money is spent to promote that general welfare, the idea of general welfare is thereby shaped by Congress, not the states, and localities have to yield to that federal decision under the supremacy doctrines. So, having found that the Title II provision, the benefits program itself, was constitutional, the court said that there's no reason to get into the discussion about Title VIII because, as it was argued by those bringing the suit, they were causally related. If Title II was bad, it dragged Title VIII down with it. Well, in this case, Title II is found to be just fine. It's constitutional, so there's no reason to talk about Title VIII. So the end result of all of this is that the Social Security Act was affirmed as constitutional, and the court was reading explicitly the General Welfare Clause to mean the ability of Congress to pass legislation to basically address issues such as unemployment, which has reiterated throughout the last 70 or 80 years and forms a large basis of government spending today, including, if you're in the United States, ideas like the stimulus checks, which we've been discussing on and off for the last year. So that was Helvering. I hope you enjoyed it. Reach out in the comments down below. Let me know what you think. Is Judge Cardozo right, wrong, somewhere in between, and why? But until we are together again, I hope everyone is well, and if you are stuck in the snow like I am, I hope you're enjoying it. Have a good one, everybody.